It appears that we have both counsel with us today. Wait for a moment. There's Judge Black. Mr. Paget, it's my understanding you represent the appellant in this matter.
I do, Your Honor.
And did you wish to reserve any time for rebuttal?
I do, Your Honor. I'd like to reserve 5 minutes.
Thank you, counsel. You may proceed.
May it please the court, my name is Stan Paget. I represent the appellants, James Cordier and Michael Gross. In this interlocutory appeal, the appellants asked the court to reverse the trial court's decision denying their motion to dismiss for improper venue. This case arises out of an account that the Motleys, the appellees, opened to trade commodities futures options. In the United States, the commodity trading business is exclusively federally regulated under a statute called the Commodity Exchange Act. It's analogous to the Securities Exchange Act on the securities side.
Talking about the account with FC Stone Financial.
I'm sorry, Your Honor?
Are you referring to the FC Stone Financial account that they opened?
Yes, sir.
Or the agreement that was signed with option sellers and Cordier?
That is, the FC Stone agreement that the Motley signed is a 36 numbered page agreement. Pages 33 to 36 are a managed account agreement and power of attorney and a third-party controller statement that are signed by option sellers and the Motleys as part of the FC Stone account opening documents. It was signed on behalf of option sellers by Mr. Cordier. The regulatory scheme that you're dealing with, Your Honor, is the Commodity Exchange Act establishes a regulatory body, the Commodity Futures Trading Commission, the CFTC, comparable to the SEC. Beneath that, there is a self-regulatory organization called the National Futures Association, the NFA, comparable to FINRA on the securities side. Beneath that, you have the Futures Commission Merchant International, FC Stone, been referred to throughout this case as FC Stone.
Well, without all that mumbo jumbo, was option sellers a party to the agreement with Stone or not?
They were parties certainly to part of it, Judge, because they're part of the numbered pages of the FC Stone agreement are option sellers signing to be the third-party manager and the power of attorney for the Motleys.
So you just told me that they're not a party to the agreement then, is that correct?
I would say that they are not a direct party. They certainly are signatories to the agreement in the sense that they have specific responsibilities.
Okay, so are you saying that because you need that argument in order to prevail, or is there another argument that you could prevail for someone who is merely a signatory to a third-party agreement with Stone?
I don't need that to prevail, Your Honor, because the way
you don't write to how you prevail despite the argument that they're not a party to the agreement.
Okay, because there are contracts directly between option sellers and the Motleys that were signed simultaneously as part of the same transaction. Those documents are to be construed together. In addition, this case is in a unique procedural posture.
Okay, so let's just break that down because I don't want to miss something. Okay. So there's a venue provision with Stone in the agreement that requires litigation in, I think, Chicago, right? But
yes,
there's
sir.
no venue provision in the agreement between option sellers and Cordier with this plaintiff, correct?
Correct. That is correct, Your Honor.
Okay, but your argument then becomes you have to construe everything together because they're executed on or about the same time. And therefore, you ride the coattails of the agreement that says venues in Chicago, and therefore, let's get the whole thing in Chicago. Does that summarize it pretty good or not?
That's one of the two arguments, Your Honor. Yes, absolutely.
Okay. All right.
The second argument is that this is a unique case in terms of its procedural posture. There's been no argument below or on appeal that the FC Stone venue provision is permissive. It is mandatory. The appellees have not argued to the contrary. In the trial court level, the Motleys sued Option Sellers Inc. and Cordier and Gross on a 5-count complaint circuit court in Hillsborough County for common law fraud, negligent misrepresentation, breach of fiduciary duty, negligence, and a 5th claim that was asserted only against option sellers for negligent supervision. All of the defendants, option sellers, Cordier and Gross, moved to dismiss for improper venue based upon the FC Stone venue provision. The trial court found as a matter of fact that the FC Stone agreement covered option sellers and dismissed all of the claims against option sellers, including the fraud and breach of fiduciary duty, negligent misrepresentation, and negligence claims that remain pending against Courtier and Gross. Under Rule 9.110K, that was a final order as to option sellers. It had to be appealed within 30 days. Courtier and Gross took a timely appeal from the court's order denying the motion to dismiss for improper venue as to them. That gave the Motleys an additional 15 days from the date of their notice of appeal to file a cross appeal.
Well, I think you're correct. There's an unappealed ruling as to option sellers, right?
That's
but if
correct,
we
Your Honor.
believe that unappealed ruling was an incorrect ruling, are we therefore bound to also say you can't sue Courtier and be done with this case and Martin?
I believe that is correct, Your Honor. And recall that because this is a motion dismissed on venue grounds, it's not a dismissal on the merits. It's simply a dismissal as to what the proper forum is for these claims. The trial court decided that option sellers was covered.
Well, my real question was, if the trial court was wrong when it made that decision, you're saying it doesn't matter, that two wrongs can make a right. In this case, we have to adopt that erroneous ruling if we believe it's wrong. I know you're saying it was correct, but I'm saying if we believe it's wrong, don't we have the option to do the right thing still?
Your Honor, actually, the case law says that the court lacks jurisdiction to review that opinion. In fact, the Donnan versus Gross case that we cited is a Florida Supreme Court case, I believe, from 1957, where the court sua sponte raised the jurisdictional issue in exactly these circumstances, where a judgment as to a final order as to one party was not timely appealed. They tried to then appeal that order as part of an appeal of the final judgment against the other party. Florida Supreme Court kicked that sua sponte and basically chided the lawyers for not pointing out the lack of jurisdiction. So the odd procedural posture, Judge, is whether that factual finding by Judge Stevens was correct or not, that option sellers is covered by the SC Stone agreement. It's final, it's unappealable. And there's a case out of I believe it's the first DCA, Gillespie versus Bowden, that says that type of an unappealed factual finding becomes law of the case. What you have is you have a decision, unappealed, final, that says option sellers as an entity is covered by the FC Stone agreement, including the venue provision, and all of those claims go to Chicago. Then you look at the claims that have been made by the Motleys in this case. They're for losses in their commodity account. But in every single count, 1 through 4, they allege that Courtier and Gross, that option sellers is liable for the actions of Courtier and Gross on a theory of respondeat liability. Under the Supreme Court's decision in Mercury Motors Express versus Smith, the only way an employer is vicariously liable on a respondeat basis is if the employee is acting within the scope and course of his employment. So the effect of the pleading is they pled that Courtier and Gross were acting within the scope and course of their employment with OSI. The cases that we cited in the brief, Your Honor, with respect to whether or not employees are covered by these types of agreements, Malamed case, Aquin Financial, I will apologize for the pronunciation of this one, Coechli, it's Koechli, all provide that non-signatories, being employees, officers, directors, are covered by these agreements. Interestingly, the answer brief doesn't cite, distinguish, or argue against any of those cases. It simply ignores the issue because there isn't an issue. There's no answer. When OSI is covered by that agreement, its employees and agents, including Courtier, who is alleged by them to be the president, sole owner, head trader, alter ego, Gross, who's alleged to be an employee, head of marketing, and a principal person, they are covered by the agreement because the complaint alleges they were acting within the scope and course of their authority for option sellers. The court really comes down to a circumstance where the Florida Supreme Court has basically said that the courts don't relieve parties of their tactical decisions. There's a case, I believe it's Miller versus Fortune Insurance Company, 484 Southern 2nd, 1221, Florida Supreme Court, 1986, says they're explaining a prior decision in a case called Randall on the effect of taking a voluntary dismissal. And it says, quote, judgmental error by the plaintiff is not the kind of mistake, inadvertence, or excusable neglect contemplated by Rule 1.540. The plaintiff bears the risk of judgmental decisions. The courts will not relieve parties of their tactical decisions. And the answer brief in this case makes clear that not appealing the option seller's decision was a tactical decision. Page 12 of the answer brief, quote, appellees have not appealed that portion of the trial court's order dismissing their claims against option sellers because appellees believe option sellers to be a defunct shell with no assets to satisfy a judgment. That is a tactical decision of exactly the kind the Supreme Court talked about in Miller, that the court simply can't relieve the party from. The answer brief goes
Well,
to great.
I can agree on the face of the record. It seems illogical to grant the motion as to option sellers and then it be law of the case, but it only applies as to option sellers. You need to import your backup argument saying, oh, by the way, that's binding on Courtier. And Courtier owned option sellers. Option sellers is a wholly owned subsidiary. So the tactical decision, I don't see the argument that infiltrates the entire appeal in this case. I just think there's two different parties involved, two different issues. The trial court got it wrong on option sellers and they decided not to appeal it, and they could have. That's a tactical decision that I don't think does them any particular harm in this appeal as to Courtier, but I could be wrong. That's my, easy take. You probably already detected.
All right, Your Honor, the cases that we cited in the Section 1E of the brief that talk about that issue, the Malamed case is a securities case, 10b-5, 517 case. They sue both Merrill Lynch and its broker, Brian Sheen, and they all moved to arbitrate. The trial court in that case rejected the motion to arbitrate 2 or 3 times. And finally, the court said, no, everybody gets to arbitrate, including Mr. Sheen, who was he was basically an employee of Merrill Lynch. He was not a signatory to the contract, the account agreement between Merrill Lynch and its customer, Malamed. In Aquin Financial, you've got a situation where you have 3 directors who get sued for all of the same sorts of claims that we see in this case, fraud, breach of fiduciary duty. And the court didn't have any concern about simply saying, you got to go do that. They're covered. There's arbitration language between the principal parties. They're covered. The Coetchley decision is even broader. That's a ship renovation contract between a company called Alpha, who owned the ship, BIP, who was the renovation contractor. There was a dispute between Alpha and BIP. Their contract contained an arbitration provision. BIP sued a separate, one of the officers of Alpha individually, and sued somebody, a gentleman who was an agent, basically had been appointed by Alpha separately, sort of as an owner's representative to oversee the construction, the renovation project. And his company sued both of them. They weren't signatories to the Alpha BIP contract. They weren't parties to the Alpha BIP contract in any way, shape, or form, but they were covered by the arbitration provision. One of the other cases that's worth noting, Your Honor, is a Citigroup Inc. versus Caputo, 957 Southern 2nd 98. It's a 4th DCA decision from 2007. There were multiple individual defendants, I believe 8 actually in that case. And the claims against all the individual defendants included breach of fiduciary duty, fraud, negligence, negligent misrepresentation, conspiracy to market a fraudulent tax shelter, all related to advice that Citigroup in one of its formations gave to open an account that was supposed to provide significant tax benefits. In that case, the 4th DCA reversed a denial of a motion to dismiss for improper venue as to all of the defendants, including all the individual defendants, none of whom were parties to the contract, none of whom signed the contract. And it is, other than 1 or 2 of them, doesn't even say that they were directors of Citigroup. They were simply people involved, no different than Courtier and Gross in this case. And in addition, the court in Caputo bound Caputo's separate company, EGC, that he set up to facilitate this tax strategy. It bound that company, which was a non-signatory to the agreement, to Coetchley's agreement or Caputo's agreement with Citigroup, It wasn't a party to that at all. And the DCA didn't have any problem saying that you're intimately related, it's interrelated, it's substantively related, it's transactionally related. EGC, you got to you got to follow the Citigroup venue provision as well.
You are almost at 15.
All right. For the reasons stated in the briefs and the argument, Your Honor, Cordier and Gross request that the court reverse the trial court's decision and grant their motion to dismiss for improper venue. Thank you.
Thank you, counsel. Mr. Vitullo?
Yes, good morning, Your Honor. Good morning, Your Honors. May it
Good morning.
please the court. My name is Anthony Vitullo, and I represent the appellees Mark and Cynthia Motley. I want to begin by laying out some key important facts that opposing counsel is not identifying for this court, which is important in distinguishing the line of cases that counsel just discussed, the Coetzee case, the Merrill Lynch case, and also the Citigroup case. In this particular case, one of the governing agreements is an agreement between FC Stone and Motley's that is called the customer agreement. That is the agreement and the only agreement that has the form selection clause. That agreement was not signed by option sellers.
Were they a signatory to it?
They were not a signatory to it. If the court will look at the page 81 of the record, it is clear that the only signatories to that agreement are Cynthia Motley and Mark Motley. Now, there is absolutely no agreement, no contract whatsoever between the Motleys and also Cordier and Gross. No agreement whatsoever. No written agreement. There is two agreements between the Motleys and option sellers. That option sellers is a signatory to the agreement. The Motleys are a signatory to the agreement, but that agreement does not contain a form selection clause. And so the line of cases that counsel has showed you and has argued involve a principal corporation signing an agreement that contained a form selection clause. Citigroup signed an agreement with the customer that had a form selection clause. The court in that case determined that Citi Private Bank and Citibank NA and the employee of Citibank were covered under that agreement as non-signatories because the parent corporation of that entity signed an agreement that had a form selection clause. In this case, we have no facts whatsoever that Cordier or Gross or option seller is a subsidiary of FC Stone, is in any way an employee of FC Stone, is in any way governed by the agreement between FC Stone and the Motleys.
Did the trial court make a ruling that the FC Stone agreement applied to option sellers when it transferred that portion of the case to Chicago?
I believe what the trial court did in that case, Your Honor, at the time the Motleys had an arbitration proceeding pending in Chicago against FC Stone, in which FC Stone had made option sellers a third-party defendant in that arbitration. And so one of the issues that the court was struggling with was dealing with my argument that in this particular case, Your Honor, it doesn't make sense for the Motleys to be unable to sue Florida residents, Mr. Cordier, a Florida resident, Mr. Gross, who committed a tort in Florida.
But we don't have that per se in black and white in this record, do we? That's your supposition.
No, I made that argument, and the court and part of the trial, part of the transcript on the motion to dismiss hearing was evidence that option sellers was,
Well, yes, I understand what you're saying, but his argument is, hey, we have an unappealed ruling, therefore it's law of the case. You do it to one, you got to do it to the other. It doesn't make sense. It's illogical, and therefore we win.
and I think that this court, I think, Your Honor, you asked the question, and that is it exactly binding upon Cordier and Gross if the trial court got it wrong as to option sellers? In my opinion, the trial court got it wrong as to option sellers, but that does not matter as it relates to Mr. Padgett's argument, because what Mr. Padgett is arguing is that in some way, by failing to appeal the trial court's decision as to option sellers, the Motleys have waived their right to exercise the argument that the form selection clause as to Cordier and Gross does not apply to them. And as you know, we've all been taught in law school that a waiver is an intentional relinquishment of a known right. The Motleys have not intentionally relinquished a right to make the argument that Cordier and Gross are not covered under the FC Stone agreement that has the form selection clause, just because the trial court got it wrong as to option sellers. And so not only did we not waive that argument or waive that, there's not been any judicial estoppel of that, because our position has always been the same, and that is option sellers, Cordier and Gross, are not covered under the agreement because they are not signatories. And so in this particular instance, the only way Cordier and Gross can be covered under the FC Stone agreement is if they were intended third-party beneficiaries. And if the court examines the actual language of the form selection clause, which appears on the record on page 79, the court will see how narrow that form selection clause is, in that it specifically states that the customer agrees controversies between FCM and customer arising out of this agreement, regardless of the manner of resolution, shall be arbitrated or litigated in the court of law in Chicago. And it's a narrow agreement between FC Stone and the Motleys. In addition, the option sellers agreement that has a agency authority agreement and commission agreement, which is one of the only agreements that option sellers signed with the Motleys, has an integration clause. And in that integration clause, it specifically states that this agreement between the Motleys and option sellers constitutes the entire agreement between the parties, and there are no modifications or amendments to it. And so this FC Stone form selection clause is so very narrow that the only way for the Cordiers and the Gross to have that apply to them is to look at the Florida court's analysis in the Leatherwood opinion and also in the Turnkey opinion. And those are the only two rare instances in which the Florida courts will allow a non-signatory of a contract to utilize the benefit of a form selection clause between parties that are completely different. And this is why the courts have gone through a three-step analysis to determine whether or not Cordier and Gross would ever apply. And so in the Turnkey versus Gawad opinion, the Fifth District laid out this three-prong test. The first prong of the test is there must exist a close relationship between the non-signator and the signator. And the Florida courts have laid out in both the Citigroup case that Mr. Paget cited and the Deloitte Touche opinion, and also the East Coast Marsh Karate School Studio opinion, what constitutes a close relationship. That does not apply in this case, because in the Citigroup case, the close relationship was Citigroup Inc., the parent company, Citibank Private Group, and Citibank NA, which were, as the Court of Appeals stated in that opinion, one in the same. And that was the type of close relationship that the court looked at. In the Deloitte Touche case, the close relationship that the court determined satisfied that prong was the parent company Gencor and its wholly owned subsidiary Gencor AP. That's not the facts in our case. In the East Coast Karate Studio opinion, the close relationship in that case was a husband and a wife. And so the first prong is not even satisfied for Courtier and Gross in order for them to trigger this form selection clause between FC Stone. But let's go to the second prong. The second prong of that test, the Florida courts specifically state that the interest of the non-signator must derive from the interest contained in the signator's contract. That, again, is not applicable in this case. In the Deloitte case, the court, in analyzing this prong, determined that since Deloitte was doing an audit of a wholly owned subsidiary who was not who was a signator to a form selection clause, its parent company, who did not sign it, had reaped the benefits of this audit because the parent company was going to use that audit for purposes of filing a 10K. And so the non-signator's interests were directly derivative of the interest between the subsidiary. We don't have that in this particular case. In the East Coast Karate case, that was an opinion where the husband was an instructor of a karate school, signed a non-compete and left, and then went to work for his wife's karate school. And the wife was not a signator to the non-compete. The court in that case said, but the wife's interests in trying to exclude or make the non-compete non-enforceable was derived directly from the contract that contained the form selection clause. In this case, we have your garden variety fraud, misrepresentation, breach of fiduciary duty claims that were made by Courtier and by Gross that in no way derived from the FC Stone agreement with the Motleys, which was to set up an account. In no way. And so then we go to the third prong. Again, the third prong of this test, the Florida courts want to analyze the plaintiff's claims must arise directly out of the contract that contains the form selection clause. Again, if you look at the turnkey opinion and also the Leatherwood card service opinion, those are the two opinions which I believe are directly on point with the facts in this case. In the Leatherwood opinion, in that particular case, the plaintiff owned a company that entered into a merchant agreement with card service. That entity did not pay the bills. Card service reported not only that entity, but the owner of that entity to the credit bureau and also slandered the owner who was not a signator to the agreement. And so the question became, does the non-signator's slander claims, does it arise out of the merchant agreement between the merchant and a company that the plaintiff wholly owned? And the court in that case said no. And here's the language that the courts cited in Leatherwood. Leatherwood's cause of action did not involve matters relating to the agreement or the interpretation, performance, or breach of the agreement. Instead, the cause of action alleged actions taken by card service against Leatherwood personally to slander his credit and fraudulently force him to pay. And so the Motley's claims in no way arise out of their contract with FC Stone. The Motley's claims are tort claims, fraud claims, breach of fiduciary duty claims that arise out of their direct relationship with Mr. Cordier and Mr. Gross, and the representations and statements that Mr. Cordier and Mr. Gross made to the Motleys that were false. And so, again, under the Florida court's analysis, Mr. Padgett and Cordier and Gross cannot satisfy the third prong of the analysis that this courts go through. And so, based on the record, and what's also interesting about the Leatherwood opinion and the Citibank opinion is that in the Citigroup opinion, there was an affidavit that laid out the nature of the relationship between the parties, and the courts recognized and took note of that affidavit laid out how Citigroup and Citibank NA and the employee of Citibank were basically entities one and of the same. In this particular instance, there has been no affidavit whatsoever submitted by Mr. Cordier or Mr. Gross that says that Mr. Cordier and Mr. Gross are so closely related to FC Stone that they are a wholly owned subsidiary of FC Stone, that they are employees of FC Stone, that all of their interests derive from the FC Stone agreement.
I think that statement is not in dispute, because your clients could have picked any investment operator they wanted to. They weren't locked into FC Stone. They could have picked anyone.
Correct.
So I mean,
Correct.
I don't think there's any. You don't need to belabor that point. I think that's pretty patent.
Okay. Thank you. And so, since Cordier and Gross, in conclusion, Your Honors, since Cordier and Gross were not parties to the agreement, were not intended beneficiaries to the agreement, were not signatories to the agreement, and the facts in this case do not satisfy the three-prong test laid out in the Leatherwood opinion and the Turnkey opinion, the Court of Appeals should deny Mr. Padgett's request to overturn the trial court's opinion, because, as you know, Your Honor, what they're really trying to say, which makes no sense, is that you should dismiss a lawsuit against a Florida defendant, a Florida resident, two of them, who committed torts in the state of Florida, and move the case to Illinois, where there is absolutely no witness in Illinois or any party in Illinois other than FC Stone. All of the witnesses in this particular case are in Florida. The defendants are in Florida. The document evidence is in Florida. And so what Mr. Padgett is asking this court to do not only is inconsistent with the principles of law, but just makes absolutely no sense to do. And so on that basis, I thank the court for your time and attention, and I respectfully request that this court uphold the trial court's decision.
Thank you, counsel. Let me adjust the clock here. Okay. Mr. Padgett, you have your rebuttal time of 5 minutes remaining.
Thank you, Your Honor. First, what you really heard was an argument for almost 20 minutes of the trial court got it wrong as to OSI. There was never any discussion of why OSI and Courtier and Gross should not be covered by that ruling, because there really is no response. And in terms of what the trial court ruled, let me be clear. At page 46 and 47 of the transcript of the hearing, dated February 24, 20, here's the court's ruling. Quote, I am inclined to think that the entities that are designated as agents in their capacity as agents, which only to me extends to their corporate capacities, I think they're swept up within the scope of this contract and that they probably have to go to Chicago, but I don't think that applies to the individuals. The court goes on page 47, quote, ruling will be today is that if you want it, the venue of the case to the extent it's against the corporate entities needs to go to Chicago, period, end of quote. So the court's ruling was very specific. It made a finding that option sellers was covered by the FC Stone agreement. That finding was not appealed under the Gillespie decision. That is law of the case. Now, the other argument that you heard a great deal about is this integration clause. And let me break that one down very quickly. The agreement between the Motleys and option sellers was signed at the exact same time as the agreements between FC Stone and option sellers and Motley, which specifically included the third-party controller, the power of attorney, the management agreement. So you can't simply look at them in a vacuum. The case that we cited and discussed, the international case, and I believe it's from this district, it talks about when you have contracts that are signed at the same time, even if they're among slightly different parties, you construe them together to make sense of them. I believe the language is, it's International Ship Repair and Marine. The court concludes international ships contention that the tri-party agreement, the easement agreement are separate and distinct is not well-founded. Indeed, we, as did the lower court, find the agreements to be functionally intertwined. Moreover, statements within the agreements contemplate the achievement of interrelated objectives. Here we follow the doctrine that where two or more documents are executed by the same parties at or near the same time in the course of the same transaction and concern the same subject matter, they will be read and construed together. That is exactly what we've asked, that the court was asked to do, the lower court was asked to do, and simply made a factual finding that as an agent, that option sellers was covered by the FC Stone agreement. It's interesting that they're alleging now that the actions of Courtier and Gross don't arise out of the relationship with FC Stone. That is directly contrary to what they alleged in the NFA arbitration complaint that's part of the record here. That option sellers, in fact, was an agent of FC Stone, was acting within the course and scope of its agreement with FC Stone. That's you getting the yin and the yang because they are sort of hoisted on their own petard. They lost an argument about option sellers being covered by the FC Stone agreement and its venue provision in the trial court. They didn't appeal it. And everything you heard was a request for this court to relieve them of that tactical decision. The court should decline that invitation and rule that the motion to dismiss as to Courtier and Gross should also have been granted for improper venue. Thank you, Your Honor.
Thank you, counsel. Thank you both for appearing. Have a safe day today.